Hello, hello. Ooh, only person in the chat is pro se plaintiff. Stressful. Not really. How's it going, buddy? How you doing? Ooh, we got two people in the chat. Is my audio working? Can you hear me? Test, 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 test. Well, that's a new feature. We have our own question and answer function now, apparently. Do we have any questions? Real laws. I am wearing a snowman costume. You're correct, John Doe. So real laws. Oh, okay. So Elia Brow asks, "Hi, have you ever represented medical residents?" Yes, in a variety of issues, ranging from sexual harassment to workplace discrimination to licensing issues. Perceived disability is a big one with medical residents right now, where like hospitals are trying to get out ahead of like suicide rates and stuff like that, but they're like assuming that certain residents have mental illness, that they're dealing with depression, things of that nature, and like doing horrible things to them based on that when there's no reason to believe that's true. So yeah, we've represented a number of medical residents, medical professionals at different levels. Real Laws asks us, what happens if your employer runs from being served? That's not probably that likely. Real Laws. First and foremost, most employers are going to have a brick and mortar place of business. That's going to be very easy for them to be served at. Generally, it's rare for an employer to even resist service, but where you have an issue, where they're actually running, like if you have like trying to think like a general contractor who's never in the same place and doesn't have a physical place of business, you just hire a good process server. And listen, good process servers are worth their weight in gold. It'd be incredibly rare that you would have to worry about this, but you get a really good process server, they take care of it. It's not something the attorney takes care of. It's not something you would personally take care of. In most jurisdictions, you personally can't if you're the plaintiff. So there's that. Marcus Anderson asks, do you see potential in this guy, or are you introducing a plaintiff side employment attorney to the masses? Marcus, I think you're talking about Attorney Castillo, who we had our first part of our series with this morning. I don't know anything. I've never seen Attorney Castillo's work. However, I will say this. Attorney Castillo, in my conversations with him, said all the right things. All the right things, and that's more than you get from the average employment attorney. It's definitely more than you get from the average young employment attorney. Like I talk to young employment attorneys who are like, the conversations range from, I'm scared to go to court, to show me the easy money, bro. Like, they can be a bit disheartening, especially because we're in a field where we need more attorneys. Desperately, right? Like, there's not enough attorneys in this field. There's not enough in most jurisdictions, and there's also certainly not enough just in aggregate nationwide. So I think Attorney Castillo has a lot of potential, and I'm really excited to watch his practice grow. And I suspect that he's going to be fantastic. That's why I highlighted him, and I hope that, listen, he's talking about a YouTube channel. It would be awesome. It'd be awesome to have him out there answering questions for folks. Because listen, I can't. There's no way. Like, even if I did 30 videos a day, I feel like I wouldn't be answering all the questions. So yeah, I'm excited about him. What's next? Nolan, thank you. Thank you for saying you hear me. I appreciate that. I always worry about the microphone on these live feeds. John Doe CK says, I think Vince did a video with Attorney Castillo because Francisco Fernandez del Castillo actually wants to help poor people, which is rare AF. Yeah, that's a big part of it. I mean, that's also, like, there's this weird issue in our field where, and I talk about this a lot with my own career, like, as you get more, as you get more notoriety in the field, as people are more and more eager to work with you, the net worth of your clients goes up, which is good for the firm. The firm makes a lot more money, right? But it's bad for your soul, right? Like, was I happier when I was, had a little 200 square foot office in Jackson Heights, and I was, which is one of the most diverse communities in the entirety of the United States, perhaps the most diverse community in the United States, helping people day in, day out. Yeah, maybe. I mean, I don't know. It felt great. It felt great to do that. Counterpoint, I had way more cases than I should have. And my clients didn't get the level of depth that they should have gotten because they were settling cases faster than I could work cases, right? Like, if somebody comes in and offers your client 20 grand, the client's like, take it now. You're like, okay, but I just started reading your papers and I think the case is worth a lot more. Take it. Oh, okay. All right. You're the boss. Like, okay. So yeah, listen, I'm excited about his career. I'm excited that he's going to be helping people. And I think this industry, there is like this desperate need for more young attorneys in the field because we need more attorneys, but also because young attorneys in this field starting up firms tend to be the people who help the lower earning folks. And that's incredibly important. There's two kinds of employment attorneys who help low earners: new ones and shitty ones. And I want them to get help from the new ones who are going to be amazing. And I suspect Attorney Castillo is going to be amazing. What do we have here? Lemon Poppy Seed. Hello. Meow Meow. I don't know why you're retracting your messages, but I'm happy to take a look at them. Even if they're mean, that's fine. Leah Brow. What would you say if someone is being told, yes, you were discriminated against, but just get over it? I would say that's a personal decision. If you want to bring a claim, if you were discriminated against in the workplace, that is a claim. And I don't know that you should just get over it, but that's a very personal decision on your part. Viral Shedding Zombie asks, what is the white thing with the dark goggles in the background? That is my ski helmet. I have it's just it's a standard, it's nothing special. It's just a ski helmet. And the dark goggles are like transition lenses for the goggles. May HM says, good evening, Vince. The court has scheduled an initial pretrial and scheduling conference in order to disclose interested persons. And that has been scheduled for a few months out. Should my attorney, do anything until then? Yeah. I mean, stay busy. So I'm I'm not going to tell your attorney what to do, and I'm not going to list a bunch of things your attorney should be doing because there's been kind of a trend. I don't think you would do this, but there's been a trend on this channel, people being like, Vince says you ought to be doing this, and attorneys like freaking out, being like, I don't care what the YouTube guy says, which is a perfectly reasonable thing for them to say because I don't know anything about your case. But generally speaking, yes, I would say that every case should be worked aggressively. Attorneys should be keeping busy. Associates especially should be keeping busy. Like a lot of times associates, you do like caseless meetings, and associates be like, oh yeah, that's just waiting on an order from the judge. And you know, that might be fine for a 2-week caseless meeting, but like it goes on into the next 2 weeks and you're like, okay, still waiting on an order. That's great. You could be waiting on an order for a year. So what are you doing right now to add value and reduce risk? Like, what are you doing? And that could just, listen, what are you doing could be that you're sitting and thinking about what you can be doing. That's okay. But like, you need to be spending time. You need to be spending time helping people. And so, yeah, I think your attorney should be staying busy. Marcus Anderson says, how do you feel if the in-house counsel conducts an investigation but never questions the bad actors and complaints? For my opinion and ways to avoid fact findings. Not sure I fully understood the question, but if they conducted an investigation and they didn't ask you anything and they didn't ask the bad actors anything, that sounds like a sham investigation. Just first impressions, hot take. John Doe CK asks, which of those two are you? So I think you're referencing, so I said two kinds of people help low earning plaintiffs, new attorneys and bad attorneys. We do. Oh, and so John Doe asks, which of those two are you? Seems you like me in a third category. So I'm in like I'm very fortunate, right? So people from all over the country call me. Often they're they're very well-to-do people, high-earning people. Sometimes they're reality TV stars. Sometimes they're fighting with famous people. I'm very fortunate in that way. So my client stream tends to be extraordinarily well-heeled. And I do still help people who are not. We make it a point. We try to help as many as we can, but we really reached the determination that we can't help more than 450 per year. So it is what it is. May HM, I am thrilled to host this session. I hope something I do is useful. By the way, we are joined by our guest star today, a casual Talisker 10. It's delicious. You're correct that I should not have ice in it, but I am on here for an hour and a half, so gotta slow things down. Aaliyah Brow says, how early before an EEOC appointment should you find a lawyer? As early as you can. I would have so in my perfect world, Aaliyah, which is a tremendously cool name, Aaliyah, really sounds beautiful. I would tell you that the initial filing with the EEOC should be handled by an attorney. So as soon as you can. Betty Lynn asks us, excuse me. Hi, Vincent. My current attorney said he or she cannot continue with my case and insists I look for another attorney, for other attorneys by yourself. Can I look for attorneys by myself? Which is better? So yeah, you can look for attorneys without your attorney's help. I would get a letter from your attorney being like, hey, we're not going to assert any lien. We're going to be exiting this case. We're exiting on good terms. And, get a good reason from your attorney why you exited the case. Because sometimes attorneys will be a little suspicious. Like, why is this attorney who worked on this case dumping it? So it can help to know why. So just get a letter from that attorney. Be like, okay, sure, I'll look for an attorney, but you got to drop your lien and you got to write a little letter. It's going to help me. And I think that'd be very reasonable on both sides. May HM, so it will be quiet. There's not going to be like action by the court or deadlines in that window, right? If you have a pretrial order coming, like a scheduling order coming up, fair is fair. That things are not going to happen for a while, but that doesn't mean your attorney can't stay busy. That's my point, right? Like, what is the attorney doing to add value, reduce risk? Sean says, Vince, I reported a manager to HR because of discrimination and harassment because of my due to my protected class. Less than 3 months later, I was deprived of a promotion. Can it be seen as retaliation? Excuse me. Yes, it absolutely can. It absolutely could be seen as retaliation. I don't know the specifics, but I would say that it absolutely could. Nina 2003 says, when Eric issues, I assume that's a misspelling, when the EEOC issues a right to sue letter, is that permission to sue only the employer or the individuals as well? Nina 2003 then said EEOC little asterisk. So, Nina, that is, you are seeking permission to sue the employer. There are some federal laws that allow you to sue individuals as well. Those, generally speaking, do not require a right to sue letter. Betty Lynn asked us about changing attorneys, and she clarifies, my current attorney is contingency based. Yeah, that's why you want that attorney to drop the lien. The lien is something that a contingency attorney asserts after getting off a case when they're still trying to collect something, right? So what you want is like, this attorney's getting off the case. You got to be like, listen, drop the lien so I can go hire another contingency attorney. Nolan says, I don't like the question and answer feature. I am sorry. I don't know how. I guess I can go back and forth. Nolan has asked a question in the question and answer feature. Nolan asks us, assume one employer has multiple violations of FMLA regulations, like 6 counts of interference, 7 counts of retaliation, but never fired, which makes damages almost non-existent beyond 13 violations. I don't know if that's a question. What's your question? Okay. Tell me, just specify the question a little bit more, and I will go back and I will try to answer that for you. Just what are you asking, type of thing. Remember, with FMLA, there's the damages for FMLA are not calculated exactly like the damages for workplace discrimination, workplace sexual harassment. Marcus Anderson asks us, Vince, when you are old and wrinkly, you'll be flying all over the place for cases because of your passion. I appreciate you and all you do for us poor persons. So, Marcus, I am already old and wrinkly. I don't know if you can see how white the hair is, but I appreciate it. I don't see myself settling down or slowing down anytime soon. Matthew asks us, I have 5 failure to hire cases endorsed by my state agency. I make $80K per year regularly. How much should I expect to get in settlements? How long is the timeline? Matthew, you're not going to like my answer. My answer is go check out our damages calculation playlist. It's going to depend on a variety of factors. There's a lot that goes into that calculation. So, I don't know here. I also don't know the nature of the cases. If they were like, listen, I don't know what your protected class is. I don't know where you are. I don't know what the state agency is. But also there's different levels of failure to hire. Like if you go to a job and somebody drops a racial slur and says, don't apply here, that's probably going to be worth more than someone casually just being like, oh, you're not a good fit. And then us thinking that might be tied to a protected class, right? So, Matthew, there's got to hit that damages calculation playlist. The timeline is also tied to the state agency that you're in. Although often, if you already have probable cause, I would think the hearing would happen within 6 months in many cases. Pamaroon, welcome back. If an attorney is representing 2 people in a sexual harassment case against the same employer and they are both coworkers, how does the fee work for said attorney in these situations? I mean, it depends on the attorney. If I had 2 separate sexual harassment cases for 2 separate employees, each of those would have their own retainer and they would owe my percentage on each of those cases. Although if you go to federal litigation and you have a if you have a lodestar, a fee application, you would probably say, well, if we did the trial for both people, we would apply the fees granted over the course of that to offset the contingencies. So like if I got $500,000 in attorney's fees from the court and my percentage was like $600,000 from both of them. Like I'd probably take 50K from both of them, right? That would probably be the fair way for that to work out. May HM, I'm thrilled to give you answers. I hope they're good. Edicts. Neil says, what to do if the district court never rules on your motions or only the opposing party's motions? Are you pro se edicts? If you're pro se, that my answer is going to be a little bit different than if you're represented by counsel. Let me know. I will keep an eye out and I will return to this. YouTube user DK says, I have an age discrimination claim against my former employer. They have an attorney through their EPLI company. Do these attorneys tend to be less experienced than if my company had retained its own firm? So two answers. So you said, are they less experienced? No. Insurance defense attorneys are super experienced. They have lots of repetitions. However, those repetitions all occur in an incredibly overworked environment because insurance defense firms, providing insurance defense work, are volume gigs, right? So they're always trying to get down the cost of representation on their end. So like, whereas like a true defense firm, like if you're going to go hire an employment defense firm, 800, 900, 1600 an hour, all in the range, right? Budget options like Jackson Lewis, all the way up to the best of the best, 16. Listen, there's people way above $1,600 an hour for defense work. Certainly reality. Your average insurance defense attorney, well, their firm might be getting paid $200, $250 an hour for their work. And their bonuses are all tied on billing big amounts of hours. So they've got fat caseloads, like heavy caseloads. And that firm is looking for